Hello, everyone, and good morning. My name is Eric Peterson. I am the Director of Technology and Innovation for the Pelican Institute. Thank you so much for joining us today. We have another exciting PeliCast. We are officially 1 week out from the election, and they have so much to cover since the last time we chatted. But before we kind of get into the conversation, I want to encourage you all to ask questions in the chat. We have some great guests today, and I know they are looking forward to answering your questions. I would also love to encourage you to hit that like button, hit that share button, help get our word out on social media for the great conversation we're going to have. I'm sure everyone on your social media feed will be excited to see something other than just politics, and they will think you're very smart for sharing our smart guests. Speaking of those guests, we've got two great ones today to talk about technology policy post-election. We have Ian Adams, who is the Executive Director of the International Center of Law and Economics. And we have Jennifer Huddleston, who's the Director of Technology and Innovation for American Action Forum. Thank you so much, both of you, for joining us today.
Thanks for having me.
Yeah, it's great to see everyone again. Jennifer came on before, and the fans were clamoring to have you back. So hard to believe the election was only 1 week ago. It seems like it's been a month with all the news. But Jennifer, I want to start with you. Kind of before the election, you did a great 4-part blog series kind of breaking down where Trump and Biden stood on various tech policies and kind of comparing to where they were. What do you think were the biggest differences that the candidates showed in your series?
I think it's interesting because with both candidates, we didn't have a really laid out, like, here's our tech policy plan, the way you might have in terms of here's our infrastructure plan, or here's our tax and spending plan, or here's our education plan. So what I had to do was dig through a lot of various statements that the candidates had made and look through some of those other plans for where there might be some comments about technology. Both of the candidates were very adamant about the need to win the race to 5G. And I think as we head into this next Congress, this is something that we'll continue to hear a lot of discussion about. Both candidates have also at various points made comments about antitrust and big tech. Now, these comments look a little bit different, but we will continue to see questions around calls to break up big tech, what that might look like, debates about, are these tech companies monopolies, different theories of harm with how it relates to the consumer welfare standard. So I would expect to continue to see that. And similarly, at various points, both candidates have actually said revoke Section 230. So I don't think that necessarily we've seen as much discussion of online content moderation from the Democrats and from now President-elect Biden, but the idea that that's something that's going to go away is not really truly the case. Some interesting areas where we have seen more discussion of tech policy from President-elect Biden and from some of the other Democrats include areas like net neutrality and calls to return to net neutrality the way it was under the Obama era, as well as some interesting things around the sharing economy. There's been a lot of support for AB 5 nationwide, a California bill that really limited the ability of a lot of sharing economy platforms to engage with their providers as independent contractors. Support for the PRO Act that would encourage unionization in some ways from these type of providers, as well as, again, make it more difficult to have these more flexible arrangements. And while a lot of that may be considered part of labor policy, it relates to technology and innovation as well, because if you're having to go through more hoops and having to consider more of these relationships as opposed to just providing a platform, it may make it more difficult to get some of these apps off the ground if you're having to consider everyone an employee rather than just being able to say, start a new app for cat sitting.
Well, as another great cat owner, a cat sitting app would certainly be helpful, especially during the holiday season. Jennifer, you hit a really good point that we tend to think of technology policy as just whatever goes on in the internet or the app store, but of course, labor policy and it has a big impact on tech policy as well. I think you hit on a few things that we're going to get about later in the concerns, but Ian, we could all use some good news. What is a good news? Are we looking at federally with it? Possible Republican Congress and a President Biden. What are going to be some areas of agreement that might move the country forward in terms of being a leader in tech?
I mean, I think the top line of good news is probably actually that both sides, their more extreme impulses when it comes to reforming major areas of concern in tech policy are going to be blunted by virtue of the fact that we're going to have divided government. So if I were to say that there's a top line of good news here, it's that whatever is going to happen, my guess is going to be incremental, it's going to be highly technical, and it's not going to be what the panacea that either side is calling for in some of their more extreme commentary. I'm coming from a place where I think that the defaults when it comes to the American legislative and regulatory approach to technology are pretty darn good. As Jennifer talks about a great deal, we tend to have a permissionless approach to innovation in this country. And to the extent that there are areas of sector-specific regulation related to technology, the U.S. is starting from a much better place than some of its geopolitical competitors around the world, right? If you look at Europe and some of what their firms are dealing with, or you look at Chinese requirements in terms of having, state involvement in the firms, the United States is coming from a much better place than that. There's a reason that we have the biggest and most robust and innovative tech sector in the world. It's not an accident. So I think that's probably the very best thing. In terms of other good news, I think it probably comes down to just a return to some level of predictability of these processes as we look to approach the regulation of technology. So we're not going to have, is my guess, 3 a.m. announcements of a need to totally overhaul content moderation policy for our largest platforms. I think that moving away from that is going to probably be a good thing for the industry, because at the end of the day, having a level of predictability when it comes to product development, product design, and ultimately searching for what consumers really want is very helpful. So that's more on the business side, but I think that having policymakers that take a different approach temperamentally is probably going to help the industry overall. And then I think to the extent we probably draw parallels from the Obama administration, there are some decent impulses here. So if we look at automated vehicles, for instance, when the very first informal guidance came out from the Obama administration, the federal automated vehicle policy, it wasn't great, right? It was a little bit prescriptive, but at the end of the day, it was informal guidance. And to the extent that the Biden administration is willing to continue down that road, as opposed to being overly prescriptive in spaces that are highly innovative and subject to change, I think that's probably a good thing. Of course, the impulse is going to be for them to be, a little bit more engaged. They're not going to be seeking outcome-based regulation. That tends to be something that Republicans do, but it's also not overly prescriptive, where they're just going to undertake rulemakings across the board, would be my guess when it comes to these newer technologies.
So let's hope for a little bit of that Clinton Republican Congress 1996 light touch from the Biden administration in areas like drones or autonomous vehicles. That's what I'm hearing as hope. I like it.
Well, I'd be interested in, Jennifer, like, do you read the tea leaves a similar way?
I do. And I think, I wasn't going to jump in immediately, but one of my thoughts is what we're also really going to see is a lot of soft law. We're going to see, this has already been a growing phenomena of the use of guidance documents, the use of informal actions, industry consultation, best practices, workshops, more of these kind of informal modes of policy making, as opposed to a lot of hard legislation and a lot of formal rulemaking. Now, I do think there may be some areas where you do see formal action, or where formal action is deemed by either side of the aisle to be needed. And I think there's a lot of question about what will happen in those scenarios. We still don't have a federal data privacy piece of legislation that's really gained bipartisan traction. And I think that's something that a lot of us expected to see this Congress. So, with that in mind, we will continue to see autonomous vehicles regulation probably done by guidance instead of by legislation from Congress or by formal action by the Department of Transportation. There may be some tweaks to what that guidance looks like, but one of the advantages of soft law is that it is more adaptive as we learn more about these technologies as well. Now, at the same time, we want to make sure guidance isn't abused and that there are checks where if these informal actions become either so uncertainty creating for the industry that they can't really function and innovate the way that they should, that there are ways to overcome or even challenge in some cases those kind of guidance documents. On the other hand, we also, have seen that this is a great way for creating a policy framework that can adapt and evolve with innovation, and that if mistakes are made, it's much more easy to correct than a top-down hard law approach.
So just to clarify for viewers, when you say soft law and guidance, what you mean are agencies like the Department of Transportation or the Federal Aviation Administration. They put out these guidance documents, and it gives those working in the space some clarity on kind of how far they can push these sorts of things without running afoul of potential federal scrutiny. So they feel like they have a framework to work in without Congress having to pass a law. Is that, would you say, an accurate description?
Absolutely.
Exactly.
Also, just how the agency may be interpreting or intending to interpret certain kind of vaguenesses that could apply to something like drones or autonomous vehicles. We see this mostly being utilized in innovation industries that are already heavily regulated. So things like transportation, things like drones, things like biomed, direct to consumer testing, things like that, health apps. Those are more where we see soft law being helpful and really utilized versus, say, something like the internet and online content moderation.
Yeah, we could certainly use positive stuff. Hopefully a lot of soft law. We did a little shaky on Congress getting together. One of the things I wanted to bring up, Jennifer, is a big concern, right, would be a return to net neutrality. Americans are online more now than ever before. Obviously, we're doing this online. A lot of us are working from home. We're going to school from home. The internet's been pretty good for those who have had connections. Speeds are up, prices are down. But there's some fear that we're going to go back to the utility style regulation of the internet by the FCC. What do you think the chances of that happening are, Jennifer?
It's interesting because this is an action that has largely been done on an agency level. And the good news is that the Restoring Internet Freedom Order happened and the internet did not break. As you mentioned, if anything, we've seen improvements, but even people who are skeptical of those improvements at time will at least admit that the worst case scenarios, the Twitter will load one word at a time type of scenario, you're going to be charged X, Y, and Z, has not come to pass. And particularly when we compare this during the pandemic to what we've seen in terms of a robust infrastructure that's able to handle the demands, we want to make sure that there are incentives for telecom companies, for new companies that are getting into the internet space to innovate and develop and deploy to withstand a growing number of connections, even after the pandemic is over, with new technologies such as the Internet of Things. That being said, I think this is a place where we have seen a lot of partisan division, particularly. And I think it is something that we could see either coming back in Congress. We've seen various bills proposed to kind of go through it a congressional route, or where we could potentially see, questions or from the FCC about continuing the current order or returning to the Obama era order instead. I think it's important, though, to recognize that the courts did uphold the current order. And even the questions that were remanded, the FCC recently responded to those and explained how this does continue to support the order. So the idea that net neutrality is something that's needed for the internet to function in its ideal state, I think the last few years have largely debunked. So, I think there's still a question out there of how much traction this will get. It does tend to be a very intensely debated issue. particularly in tech policy circles, that people have a lot of strong feelings about. And, my hope on that regard is if this debate does come back, that it can come back in a way that is more of a debate on the merits as opposed to some of the more personal attacks that got involved in the previous debate.
So I totally agree. I mean, it was truly lamentable to see the state of the discourse around net neutrality, not only on Reddit and the like, but also for members of Congress and the the overinflated rhetoric about how the internet just will cease to function, when of course we see this spike in demand as a result of the COVID pandemic, and the US network holds up incredibly well. And Europe is having to cut speeds and to meter connections just so that people can continue to have service. Now, at the end of the day, a Democratic majority at the FCC, I think, because there isn't some legislative fix here, is probably going to go back in that direction. But I think they have to keep in mind what they just saw from the US network and the advantages of ensuring that there are economic incentives for continued build out of such a robust network. And I mean, I might add on top of that, that top of mind for the Biden administration, and I think for both parties in Congress at this point, is closing the digital divide. And there are going to be different visions in terms of how to do that. But the best case study we have internationally is that a market-based approach is just simply more effective at getting high-speed internet to more people more quickly.
Yeah, one of the great bipartisan wins of the FCC over the past 4 years is closing that digital divide, whether it's rejiggering its incentive programs or making more spectrum available for 5G networks. And I think that's obviously they had some great foresight, because had they not been taking that great bipartisan action, we probably wouldn't be where we are today, even though there is still a problem with the digital divide in this country. I want to go to the state level. Of course, there were more elections that just happened at the federal level. Two particularly big ones in California were Proposition 22 and Proposition 24. We have a lot of propositions down here in Louisiana. California, however, might have a few more than even we do. We didn't have any on tech this one, but why don't you take our viewers through those two propositions and what they mean for both the future of California and tech, but also what it might mean nationally for those in other states.
Yeah, and I think California sort of, in the minds of non-Californians, has taken this place as this unalloyed liberal bastion. It is bluer than blue. You've got Democratic supermajorities in the legislature. You have Gavin Newsom, who's, of course, a very high-profile Democratic governor. And yet, when it came to questions posed directly to the voters, California really returned some interesting results. It looks like it's going to reject a fairly major tax increase. It thoroughly repudiated yet another opportunity to enact rent controls. So it's just fascinating to consider the nature of this electorate. And when it came to two major initiatives related to technology policy, it went two different directions. So Prop 22 was the referendum on AB5, which Jennifer mentioned earlier, which was going to require independent contractors to be classified by and large as employees through the imposition of a fairly onerous test for classification of those workers.
So this would have hit everyone from Uber, Lyft drivers to Postmates to Grubhub, everybody who was working in the gig economy, as it's often known.
Not only the gig economy. Yeah, it's far broader than that. It is any industry that you have independent contractors in. AB5 applies this ABC standard, as it's called, to those workers. And so Prop 22 is actually quite narrow. It relates specifically to what are called app-based drivers. So that is Uber, Lyft, Postmates. And the fact that it is so narrow is actually a little bit frustrating, because it basically says that if you have a seat at the table and if you are able to marshal the resources to bring the arguments to the people will go, it doesn't make a whole lot of sense to have this sort of standard apply to independent contractors. And so for those industries that are not Uber, Lyft, these app-based drivers, or are not insurance brokers, or are not any number of exceptions, journalists, they got a carve out. Lots of industries got carve outs from AB5, but the fact is
Oh, I think we lost Ian. I think
Well, if I
yeah, go ahead.
can
Go ahead,
jump in
Celebrated it.
here. Oh,
As a repudiation of AB5, it is very much a qualified victory. I'm sorry. Go ahead, Jennifer.
no, I was gonna say we lost you for a second, so I was gonna jump in and say I think the other interesting story here with Prop 22 and AB5 is not just, again, as Ian alluded to, we've seen California voters kind of reject this approach, at least on a limited basis, which in my opinion, given, that this was the industry largely perceived as targeted by AB5, I think would call into question in most voters' minds the purpose of AB5 to begin with. But we should also hope that other states pay attention to this, as well as federal policymakers, because we've seen other states after AB5 passed propose similar versions or propose tightening the definition of independent contractor in such a way that would make it very difficult for platforms and for businesses to employ independent contractors. We've also seen the PRO Act, whether, or not that comes back on a federal level, but it seems like there's a possibility that we could have a similar discussion, even if not that same bill. So what we've seen, though, is that when put to the voters test, it doesn't really go with this is what the people want. People may be concerned about various elements of the worker relationship in regards to how the gig economy functions, but they also recognize that this isn't the right policy tool to maybe to maybe address what their actual concerns are.
And it's going to be fascinating to see if this repudiation in California translates to the Biden administration, because on the trail, now President-elect Biden explicitly endorsed an AB5 type approach at the federal level. And when you have one of the more liberal electorates in the country saying, no, we don't want that by like 60%, I have to think that's going to raise some questions about whether it should be pursued nationally.
Yeah, it makes a lot of good points there, especially the law of unintended consequences of AB5 was mostly to go after these rideshare companies, hit a lot of other people, and then when put to the voters about those companies, like you said, pretty strong rejection. California had another one, Proposition 24, which was on privacy. Ian, can you take us through that real quick?
Yes, of course. In 2018, California passed CCPA, the California Consumer Privacy Act. Well, this can be thought of as CCPA Take Two, just more robust. If it's going to be a sequel, it has to come out with something new, something eye-catching, something that really is going to get the crowds in the theater. CPRA, the California Privacy Rights and Enforcement Act, does exactly that. It's going to create the nation's first data protection agency, so specifically a state regulatory entity that is going to be charged with enforcing California's digital privacy laws. And it has far more onerous requirements for firms on the internet to comply with. And so this passed, I must say, it wasn't seriously opposed in the state. The No on Prop 24 campaign spent under $100,000 in total, which sort of speaks to the fact that larger firms who are going to be subject to these requirements are not that bothered by it. They're actually pretty well positioned to comply with CPRA-like requirements, just as they have in Europe been able to comply with elements of GDPR. That doesn't mean it's good law. It's really problematic for all sorts of reasons, but it's also not surprising that it passed in California. You just didn't have the same amount of opposition.
If I can speak a little bit about Prop 24 and particularly the broader data privacy debate. As Ian mentioned, some of this is that larger firms, while it is incredibly costly and burdensome to comply, can largely comply. One of the things to remember when we're talking about data privacy and we're talking about a data privacy agency is how many different industries data touches. It's easy for us to think about this as, oh, that's just online advertising, or that's just social media, or that's just, the big tech companies. And I'm okay with that, type of attitude is what I feel like some people may feel because they see these scary headlines and they think that's what's needed. But a digital protection agency is also going to impact things like restaurants. It's going to impact florists. It's going to impact grocery stores with your card that you scan, or if you put your phone number in at the Publix, it's going to impact how they can provide targeted coupons and things as well. So the idea that this is just California and that this is just a tech issue doesn't really see the full breadth of data privacy debate, and does not fully see all the beneficial uses that most of us are quite frankly happy for in our daily lives. Now, one perhaps good thing out of Prop 24 passing is, as I mentioned earlier, we have not really seen momentum on the federal data privacy debate in a while. Understandably, Congress has had other priorities that they need to deal with, but California going this more onerous route, going a route that's going to have even more of an impact across state borders, particularly as we see other states. Washington is expected to consider its own Privacy Act again, that are passing different laws that make it more and more difficult on innovators to offer the same product across state lines. I think this is a key time to really reinvigorate that debate on a federal level, because having federal guidelines will be much easier on innovation and hopefully be able to preserve a lot of those benefits and choices that many consumers appreciate.
So Jennifer, we agree on virtually everything, but I have to be a little bit more bearish here. I do not think that Prop 24 is going to spark renewed interest in federal privacy legislation in at least the next 2 years, in part because it doesn't come into effect until 2023, but more broadly, like we've been doing this for so long. And I think the staff drafts that we are now seeing out of Republicans at the congressional level, at least in the Senate, substantively have started to look a lot like Democratic proposals. But of course, the two big areas where the parties disagree, one has to do with whether or not to include a private right of action. The other is about the extent to which the federal government is going to preempt state activity. I would say I don't see the parties moving on that right now, unless something changes. Something may change, right? Pandemic changed everything, but I don't see them moving on that. And to the extent we do see a new federal privacy law that is comprehensive, California is the floor. Like CPRA, like that is now your floor, which is
scary. There's a lot of bad things in this when it comes to data privacy. I think I was the last one to give up hope that we were going to see a good data privacy bill this Congress, and it was like July, and everyone else came up far earlier than that. So I do, however, think that it is important to remember that this is a debate that should be happening at a federal level.
Yes,
because in the absence of that, you're not just going to see CCPA and CPRA copycats. You're going to see bills that look different. You're going to see even the copycats are going to be enforced differently. And this is going to make it much, much tougher on an innovation that by its very nature, data flows go across state lines.
This is the reason that those of us in Louisiana have to click that we accept cookies, not because of anything the Louisiana legislature did, but because of what they're doing out in California, which I think highlights the federal nature of this problem. Jennifer, I want to finish with some optimism. Michigan passed a data privacy law. Almost 90% of the voters voted for it, which might be the most popular thing that passed in any kind of contested election this year. Talk to us a little bit about what Michigan's doing on privacy, how it's different than California, and how it might actually protect consumers.
So a lot of times when we talk about data privacy on a state level, we're talking about things like the CCPA, we're talking about things like the CPRA, and how these are disruptive bills that could potentially, splinter the internet as we know it. What Michigan did actually follows a different kind of model on privacy and is actually a different element of data privacy that often doesn't get as much attention as the ones that make you click the cookie pop-ups. So the Michigan proposition had to do with warrant requirements for law enforcement access to data. in the past, there have been some cases where law enforcement could get this with just a request or a subpoena via what was known as the third party doctrine. And what we've seen, and this third party doctrine was created in an era where you would go in and interact with a bank teller, or when you made a phone call, you would be interacting with an operator. So you knew that someone else knew that information, and you were giving up some of your privacy to the government by, in the same way that having a conversation in a public place may give up some of your privacy. Utah was the first state to really pursue these additional privacy protections around online data or data that may be collected in the future by autonomous vehicles or smart home devices and the Internet of Things. We've also seen the Supreme Court ask questions about this in a case called Carpenter, where they limited the application of the third party doctrine to cell phone location information. That case was very narrow, though, and only applied to cell phone location information. So in some cases, what we've started to see now is states kind of stepping up a bit and choosing to put these own additional privacy requirements on themselves. So that's what makes this different from the California law, is this isn't necessarily impacting you as a consumer or you as an innovator. If anything, it's giving you more control, because what it is it's the state restraining themselves. Now, some people have been concerned about, how this might impact law enforcement. And to be very clear, this is not saying that law enforcement can't get access to data. It's just clarifying that they must have a warrant in most cases to get that access, the same way that they would for certain other information that they may be seeking to obtain. So I think that that's important to consider as well, that this is not at all trying to, hinder law enforcement's investigation. It's more providing an additional check on civil liberties, which again is particularly important for some ways that privacy could be used in, say, the current public health crisis. When we're talking about contact tracing apps, a lot of people have a lot of concern about when and what the government could use this for. So looking at these kind of pieces of legislation as a potential model that provides those guardrails on privacy from government surveillance and provides individuals with a way of feeling more comfortable that their civil liberties are being protected when they may be choosing to interact with the government and give up certain information.
So that's obviously a huge win for the people of Michigan. I want to finish off rapid fire, starting with you, Ian. What is one thing you are excited about after this election in tech policy, and what is one thing you're most concerned about?
Oh boy. One thing that I'm excited about is to not talk about the election anymore, though that hasn't come to pass quite yet. No, I am excited for the complexion of the debates to evolve, right? It's always interesting to see new sorts of permutations, and I think that with the Biden administration, we're going to see different sorts of approaches than we've seen with the current administration that substantively may not be better. They may be worse, but I'm just excited for the debate to evolve beyond where it's been for the last 2 years. In terms of my top concern, I suppose my top concern is actually around the way that both parties have begun to talk about competition issues. And we haven't spent a lot of time discussing those today, and we can certainly come back and talk about some of those things. But whether you subscribe to some of the recommendations that the House Judiciary Committee just put out in a large report it just did about the state of competition in digital markets, or to the technically minority but third way report from Congressman Buck about sector-specific regulation and some remedies that should be pursued by virtue of the fact that some of these tech firms are very large. There's not a lot to celebrate there. Neither direction is particularly promising. And to the extent that we're trying to win the race to 5G, we're attempting to remain technologically preeminent in the world. It's only going to hurt the U.S. position relative to our near peer competitors internationally if we go and we take a really aggressive posture towards our largest tech champion. So that's an area of concern for me.
If you do want to check out, we did a antitrust PeliCast just a few weeks ago. So if you're interested in what Ian was talking about there, feel free to check it out, viewers. Jennifer, what are you most excited about? What are you most concerned about?
We mentioned it in passing earlier. I think there really is a bipartisan impetus to try and solve the digital divide as much as possible. I think that that is somewhere that there's a lot of agreement that has really been borne out by the pandemic. And it's a question of how do we best do that? So we've seen the current FCC engage in a lot of bipartisan action to really encourage deployment, to free up more spectrum, to allow for some creative solutions as well with satellite and 5G. So I'm most optimistic to see ideally that momentum carry forward and be an example of how bipartisanship can work on a lot of these tech policy issues. Ian already mentioned antitrust as his concern. So I will pick a different one. And I would say on that front, to stick to telecom, actually, I am a bit concerned about the return of the net neutrality debates. I think that this is a topic that often gets very heated for whatever somewhat surprising reason, and that it is something where we saw the approach once net neutrality was removed that a lot of the concerns didn't come true. And even if you think that one approach or the other is better, I certainly think that our current approach is better. The idea of a constant back and forth and what that could do to innovation, what that could do to deployment, what that could do to all these other concerns, when you have that policy uncertainty of every 4 years, depending on who's in charge at the FCC, whether or not this is a utility or not could change, that's something that I get really concerned about.
Yeah, we talked a little bit about the predictability and the regulation being super duper important, especially when it's as important as closing the digital divide. Thank you both for joining us today. If you want to check out more of Jennifer and Ian's writings or other media, where can they find you both?
You can follow me at IA the Teapot on Twitter for my hottest takes, and I'm usually retweeting what it is we're doing at ICLE, so please follow me there.
And I'm on Twitter at JR Huddles, and then most of my writing is also available on American Action Forum's website, which is americanactionforum.org.
All right, and you can find them. We tweeted them out earlier on our Pelican Tech Innovation Twitter, so check us out there. And again, before y'all go, make sure to like and share this video. Thank you all so much for tuning in. And Jennifer and Ian, thank you for joining me today.
Thank you.